law firm practicing family law. Just a little bit of housekeeping for this evening. I would ask that everybody make sure their cell phones are on silent, not vibrate. If they vibrate during the presentation, it is a little distracting to other people around you. This evening, what we'll do for our format is we'll have a presentation for about 50 minutes, an intermission for 5 to 10 minutes, so you can use the restroom, get a drink, anything like that, and then we'll come back and continue with the presentation. We have asked that questions all be kept till the end, so about 8:45 or 8:50, we'll open up for questions. And I'll actually have a microphone and walk around, and that way we can make sure everyone can hear the questions. Tonight we have a very exciting topic. It is auto no fault. As you may have heard, and hopefully have heard, there were major reforms that were done in Michigan auto no fault. And so tonight we have Steve Sinas and Tom Sinas presenting. Just a brief moment, I want to mention that next week our presentation will be by our Ingham County Clerk, Barb Byram, and she'll be talking about voting laws in the state of Michigan. In terms of Steve Sinas and Tom Sinas, there's a lot I could say about them, but I will keep it brief. They are brothers. Their grandfather, Tom, opened and started our law firm, the Sinas Dramus firm, in 1951. Their father, George, is also one of their law partners. Steve works in our Lansing office, and Tom works in our Grand Rapids office. But they both represent clients all over the state of Michigan and beyond. They both have an incredible reputation of being legal scholars, fierce litigators, and passionate advocates. In terms of their profession, both of them practice primarily personal injury law, and they both consider it an honor to advocate for those seriously injured or harmed by the wrongdoing of another person, company, or government. In terms of personal injury, they practice auto injuries, including accidents, motor vehicle collisions, semi-trucks, motorcycles, bicycle injuries as well. They both are very involved in professional organizations and have leadership positions for several state and local bar associations. They both have also won many legal awards, and more importantly, have made a real difference for the countless lives of their clients over the years. So if you guys can give them a warm welcome, we'll get started.
Good evening. Am I live? Okay, all right. All right, well, thank you all for coming here. People's Law School is a great tradition here for our community. Our firm is proud to be a part of it. We thank you for coming out tonight. This issue that we're going to talk about tonight obviously has been reported on. There's a lot of information, so we want to try to give you our take about what has happened here with regard to no-fault reform. And we use the term controversy or understanding the controversy because there is a lot of controversy regarding this issue. I just want to say a few comments and then turn it over to Tom to deal with part one of our presentation. But we have learned as lawyers and anyone who's dealt with a serious injury sustained in an auto accident that there are unique care needs, unique rehabilitation needs that seriously injured people have. And here in America, while we have health care that services many people and some of them well, it doesn't serve everybody very well. And certainly is not something that assures those catastrophically injured in motor vehicle accidents that their care and needs will be met. And so this issue about auto insurance is not just about what type of insurance we have in our vehicles, but it's about health care in America and the resources that are there to help those who have sustained serious injury in a motor vehicle crash. And so with that in mind, we want to try to give you enough background information and context and understanding about what no-fault is all about, or what the original no-fault law was all about. Tom's going to cover that in part one. And then we want to give you some further insight and context about what the reform attempts in the past have been about, and some history there. And then we're going to go into the problems that were brewing in the no-fault system over the last 10 to 15 years, and talk about why those were issues that resulted in the need to make some types of changes. And then we're going to talk about these reforms. We'll talk about how they were passed, and there's some issues there to certainly talk about. And then we're going to end with the actual reforms. So what we hope you get from this whole presentation is an understanding about what Michigan had, why the original act was implemented, what it did, the history that led up to these reforms, and now what we have going forward. So with that being said, I'm very proud and excited to introduce my brother and partner. It's always great to do stuff with him, so we're happy to have him here from Grand Rapids tonight. Tom Sinas is going to take us through part one here.
All right, thank you. Am I live? I feel like Steve Jobs. All right, so I'm going to take you on a trip way back in time. Because in order to understand where we are right now, we got to go ways back. Who finds the phrase "no fault" just by itself confusing? I do. Okay? I think it's really confusing because it doesn't really explain what we're talking about. What are we really talking about here? Who finds the phrase "car crash" confusing? Makes sense, right? We've got cars, they crash, and people get hurt. Which begs the question, how are we going to deal with this problem? It's a problem that we've had since we created the car, and it's a problem that we're going to have unless and until we have cars that don't crash. All right, so that's what this whole thing is about. What do we do about car crashes? So this slide says that it all started in 1973, but it all started way before that. So I'm going to skip because I want to talk to you about tort law, which does not refer to a small pastry. That's just also confusing. But what is tort law? Tort law is something that has existed in the United States since before it was the United States. It's existed in English common law, the law of England, became, generally speaking, the law of the United States. And it's this idea. If I harm Steve because I'm not careful, because I'm negligent, as the law says, then what do I owe Steve? Do I owe Steve anything? How do we decide whether I owe Steve anything? How much do I owe Steve? That's tort law. Make sense? Okay, so before we ever had no fault, we had tort law. And we took tort law and we applied it to car crashes. So we said, if Steve's on the road and I rear-end Steve, then his remedy is to come after me in what's called a tort suit. Or a civil lawsuit, right? That's the difference between the civil and the criminal justice system. I'm most likely not going to go to jail for rear-ending Steve. That's the criminal justice system. But Steve has a claim against me for the harm that I have caused. And before we ever had anything called no fault, that was the only way that Steve and I were going to resolve what happened to us out on Abbott Road. Okay, that's all fine and good, except there's a lot of cars. And there's a lot of people. And there's a lot of crashes. All right, and this problem doesn't go away. Maybe over time it's gotten better, but even look where we are now. As technology and automobiles has gotten better, everyone's driving down the road with their phone in their hand. So this problem, we weren't going to just be able to ignore it. We had to come up with a way to deal with it. And for decades before 1973, in Michigan, we just dealt with it the old-fashioned way. Steve had his civil lawsuit, his tort lawsuit against me, and we had to hash that thing out in court, and we'd have to figure out how much I owe him to get square with him for what I did. Make sense? That's this. An injured person can recover economic and non-economic damages from the at-fault driver. At-fault drivers can't recover anything. What does that mean? Well, if I rear-end Steve, Steve can come after me for whatever harm I've caused, but it doesn't go the other way around because I'm the guy that caused the accident. So there's two problems there. The first problem is taking me to court and sorting all that out through litigation in court is not exactly smooth and efficient. It's not quick. The other problem is, if I friend Steve, the chances are that he's not the only person who's hurt. I'm probably hurt too. And what are we going to do with me? Well, we can't just leave me on the side of the road just because I made a mistake. We got to take care of me, and we got to take care of him. That make sense? So, we decided in 1973 we're going to come up with a way to deal with this problem, or at least part of this problem. And what was happening in the 1970s, in the 60s, throughout the United States, was the advent of this concept called no fault. And it was percolating around the country in different forms. And it was basically this idea that said, look, instead of the Steves of the world having to go sue the Toms of the world for every car crash, we should create a system where both of us have some assurance that we're going to be able to get some basic things covered after a car crash. Steve should be able to get some assurance that he can get his medical expenses taken care of without necessarily having to take me to court. And it might be good if I can get myself taken care of without having to just be left on the side of the road and have to figure out whether I get my health care through my private health insurance or through government, or I go bankrupt, or whatever it may be. That's the concept of no fault. No fault. It means that we're going to give people access to certain resources after a car crash, regardless of fault. That's all it means. Regardless of fault, people involved in car crashes will get access to certain benefits.
Unless they intentionally injured.
Okay, yeah.
That's the only exception to the rule.
That's the only exception to the rule. Yeah, I mean, if I go off and intentionally run my car into the side of a building, then I'm probably out. But you get the idea, right? Otherwise, we're going to give people access to resources. And how are we going to do this? Well, we're going to make everyone buy this kind of insurance called no-fault insurance, which will give people the access to the care that they need, to the other resources that they need after a car crash. So what we did in 1973 in Michigan is we split the atom in half. And I'm going to use two different hands to refer to what we did. We said, on the one hand, we're going to have what we call no-fault benefits. And these are benefits that you can get regardless of fault. Again, I get them and Steve gets them. Doesn't matter that it's my fault. On the other half of the atom is the tort claim. Remember where I just started? I still have the right, Steve still has the right to come after me for certain kinds of things that aren't covered in the no-fault system. So think of it like this. If you can get it in the no-fault system, you can't get it in the tort system, and vice versa. And what we put into this hand, the no-fault hand, are the things that people most commonly need after an automobile crash. Most significantly what? Their medical care. We put that into this hand in Michigan. And this made us different than any other state in the United States. What did some other states do? Other states put a little bit of medical over here. Like I went to law school in Minnesota, and Minnesota has a no-fault system, but there's only $20,000 in medical expenses over here. And if you've got more than $20,000, you got to go over here to the tort hand. And other states around the country had different variations, and some still do have different variations on this no-fault system. But in 1973 in Michigan, we decided we're not going to do it that way. We're going to put all the medical over here. We're not going to have a dollar limit. We're not going to have a number of years limit. All the medical that an injured person needs as a result of an automobile accident is going to come through the no-fault system. Which means two things. It means that anyone injured, whether it's their fault or someone else's, is going to access their care through their no-fault insurance. It also means that the Steves of the world don't have to sue the Toms of the world to get their medical bills covered. Yes, he can still sue me for certain other things, but not for his medical bills. Those are being taken care of outside of court. That's the idea. So what else is in the hand? Or I should say was in the hand. The first, you see it says allowable expenses. That's the fancy term that we use for what you think of as medical expenses. The law calls it an allowable expense because it's broader than just medical. But it's the most significant thing that's in this hand because, again, it's not limited in years or dollar terms. The other thing that's in this hand is 3 years of lost wages. Again, doesn't matter who's at fault. You can recover up to 3 years of lost wages from your own no-fault insurer. You don't have to sue over the first 3 years of lost wages. And the third one is what are called replacement services. What are replacement services? They're household chores. Household chores that you can no longer do as a result of an accident. Either Steve or me, doesn't matter. We go to our own no-fault insurer in this hand, and we recover those benefits from the no-fault insurer. Everybody following so far? All right. Yes, the replacement services were limited to 3 years, as was the last one that just came up. Survivor's loss are benefits. They're similar to the other ones. They're benefits that are payable to the dependents of those who pass away. So children who lose a parent, and the parent was a breadwinner, the children can go to the no-fault insurer and they can get wage replacement, design and fringe benefit replacement designed to replace the economic contributions that their deceased mother or father made before they passed. All right? Now, I'm just going to be very honest about my view here. Michigan's no-fault insurance system, as it used to exist, was the best form of health insurance that anyone could buy. Think of it as health insurance. Don't think of it as auto insurance. It's the best form of health insurance that you could have. Because why? Because this sentence is what gave you, your family, your neighbors, anybody else, access to the medical benefits in this hand. And it was a very simple and elegant sentence, and it said, allowable expenses, it's the fancy word for the medical and related, consisting of all reasonable charges, so it had to be a reasonable charge, incurred for reasonably necessary products, services, and accommodation for an injured person's care, recovery, or rehabilitation. That's it. Products, services, and accommodations for an injured person's care, recovery, and rehabilitation. If it was one of those things, then it was an allowable expense, and it was a no-fault benefit, and you got it from your own no-fault insurer, generally speaking. You didn't have to go after the other driver for those things. So that sentence over time came to be understood as different things. It was things like, of course, your medical care, your surgery, attendant care, meaning in-home care, people who needed care at home after they went home from the hospital, rehabilitation, therapy, transportation to and from doctor's appointments, mileage, housing even, handicapped accessible housing, case managers, see one here, case management services, guardians for people who needed a guardian. All those things fell within that broad umbrella of reasonably necessary products, services, and accommodations. And it was recoverable over here. And what did you have to show? Well, you just had to show one basic thing. This is a fancy legal way of saying that I was in a car accident, or I was injured through some accidental use of a motor vehicle. If you showed that, you could open up this hand and you could access it without having to establish anybody's fault. What was the old rule? Where did you go for your no-fault benefits? The general rule was you went to your own insurance company. There's, of course, exceptions to that, but most people, if they had a car, they'd go to their insurance company. Again, Steve would go to his, I would go to mine. We would get our medical care taken care of, and that was the end of that part of the matter. We had some one-year rules, some rules you had to follow, but by and large, these benefits were paid as long as they were incurred, meaning you became liable to pay those benefits. This did differentiate no-fault from typical health care. There was no such thing in no-fault, and there isn't today, as pre-authorization. Sometimes if you want to know if your health insurance is going to cover something, you can call a 1-800 number and sit on hold for an hour, and then eventually someone will tell you, yeah, you will or won't cover that surgery. That didn't exist in No Fault. No Fault is what's called a fee-for-service system. You go to the doctor, you get a bill, your No Fault insurer pays after the bill's been incurred. Okay, so what about my tort claim? What about the old days? What about my ability, or excuse me, Steve's ability to come after me? Remember, because I caused the rear ender, even though I keep screwing this example up. Could Steve come after me for anything? In other words, what was in this hand? Well, yeah, he could come after me for certain things. And the most significant thing was what the law calls non-economic loss, which I find to be just extremely unhelpful. And then the words we use to define non-economic loss, unfortunately, are the ones that you see plastered all over the TV in the middle of the day. But what are they really? They're really quality of life damages. The idea that when someone is seriously hurt or killed, there is a change in quality of life. So Steve had that quality of life claim against me, even though his medical expenses were dealt with through his insurance company. He had his quality of life claim against me. That was in this hand. The other thing that was in this hand was the rare exception where the Steves of the world were injured and couldn't return to work after 3 years. Because where's the first 3 years of lost earnings? Over here. So for people who are catastrophically injured who can't work anymore, if those people couldn't work beyond 3 years, they pursued their claim in tort, in the liability claim. I'm going to put some of this up and I'll explain it. But we had limitations. We had some actually pretty strict limitations about when the Steves of the world could sue the Toms of the world for this hand. And the most significant one was a concept that you're going to hear referred to later called the threshold injury. And the concept is this. In our system, after we split the atom in half, in order for Steve to sue me in tort, he had to have a serious injury. There's different kinds of them. One of them was death. Another is serious permanent disfigurement. And the most commonly debated one was serious impairment of body function. But it's serious, right? The injury had to be serious. In other words, even if I was the most negligent driver you could imagine, if I was texting on my phone, drunk, and on drugs, and driving on the sidewalk, and if Steve only got some bumps and bruises because he got lucky, he could not sue me because he didn't have a threshold injury. The other circumstance under which Steve couldn't sue me is if he was more than 50% at fault. You know, sometimes it's not so clear as a rear ender. Sometimes the blame goes to both people. Well, if more than half the blame went to Steve, this hand went away. We call that the 50% comparative fault. And of course, overriding all of this is the concept that Steve would have to prove that I was at fault. If I wasn't at fault, then the tort claim doesn't exist. Okay, so suppose Steve does have a serious injury and I am at fault. Who paid my debt? Well, technically it's mine, right? I caused the accident. I caused the harm. But I carried, like most legal drivers, what? Liability insurance. That's what liability insurance is. It's insurance to protect you from claims against the people that you harm. It's not no fault. It's separate from no fault. This is why I think the phrase no fault is confusing, because when we talk about Michigan auto no fault, we're really only talking about one hand. We're talking about the no fault hand. But there's a whole other hand, the liability hand. So my insurance company would pay that claim for Steve, and if I didn't have enough, and Steve made the smart decision, as all of you should do, particularly now, and he bought what's called uninsured or underinsured motorist coverage, he might have some extra coverage to take care of him if I didn't have enough. He had 3 years to bring that claim. all the time from your insurance company, right? Shove them in our files. What are they? There's this like long menu of things that we apparently paid for. And yes, you pay for each one of these things. And if you look here, I don't know if you can read this, but on the top it says residual combined liability. What's that mean? Well, that's the amount of liability insurance that would take care of when Steve comes after me. That's the insurance that steps in to pay Steve's liability claim. Make sense? Okay. Also down here is personal injury protection. Full medical, full wage, and there's a premium. That's the no-fault insurance. And then there are other things in here, like the underinsured motorist coverage that I talked about. But this is a summary of an example of someone's insurance policy, and it shows that when you buy an auto insurance policy, you're buying different types of coverages. But for purposes of our discussion tonight, what we're really talking about is this hand and this hand. Okay, so that was the law as it existed before 1973. Excuse me. In 1973, when we passed the law. We passed the auto no-fault law in 1973, and we had then a series of small changes, but not really many at all. But most of what happened after 1973 was battled in the courts and battled in the legislature. It really didn't go anywhere until recently. So I'm going to turn the next chapter of our story over to Steve.
Thank you, Tom. So, we tried to design this presentation so each part would build on the next part, and you'd be able to really get an idea of these concepts. And let me just go back and just point out some on this declaration page. The cost for the liability insurance, you can see, is not much. Now this is a declaration page from a vehicle in 2016, and in Ingham County, 6-month policy, and really this person wasn't paying that much and had great coverage. But the liability coverage really doesn't cost that much money on this vehicle at the time. If you go to a tort law state, that number jumps up greatly because the liability insurance then has to pay so much more. Because in Michigan, we're going to get to how these reforms change this going forward, but what Tom just covered is that the medical expenses aren't recoverable from the at-fault driver. So what we have here is cheap liability insurance in Michigan because of the no-fault system. Yes, no-fault does cost, on this particular policy, about $200. The vehicle is the most expensive thing to insure, the collision coverage. It's interesting that it costs more to insure our vehicles than our bodies, but that's what this policy represents. Now, there can be variations, but if you really start looking at these numbers on a no-fault policy prior to these reforms, which is really any of these policies out there, because the reforms haven't kicked in terms of new policies yet, but you'll be able to see where you're really spending your money. Now, getting to the other parts of the story. So we have this system, and as Tom alluded to, it was in place since 1973, didn't really get changed in any major way, but there was some opposition to this system. And it's interesting because when it was implemented, the insurance industry wasn't necessarily against it. They thought maybe it was going to be a good thing. But with about 2 decades into the whole process, they realized they wanted out. And so what we have here, excuse me, getting to this is the part 2, previous failed reform attempts. Instances where there were ballot initiatives that the insurance industry and some other interested groups pushed to try to change no-fault. And what happened here with these two, Proposal D was a ballot initiative to basically repeal the no-fault law and replace it with some variation of a hybrid tort no-fault system. And that failed when the voters rejected it, 62%. And then the legislature at that point, which was more controlled by the Republicans, once the Engler administration took power, they ended up passing legislation that did repeal the no-fault law, or fundamentally changed it to make it more of a hybrid tort no-fault system with very limited no-fault benefits, and they passed it. And it was a referendum then put on the ballot in 1994, and the voters came out and said, no, we don't want that to be our law, and they repealed it. Or they had a referendum on the law. So the voters in the 90s, after being educated about the issues and the idea of reducing benefits, came out in pretty overwhelming fashion and rejected attempts to reform the system. And I can tell you that some of the reform ideas and proposals C and D form the basis of the reforms that actually passed this year. So after the voters rejected it, then the legislature continued to push it. And I'm only referencing political parties as a matter of fact. I'm not doing it within the agenda to say good or bad. I'm just telling you that it was the Republican-controlled legislature that continued to push through no-fault reform until we'll see what changed this year. But with regard to other attempts, these are just examples. 2011, there was a push. I remember being down there at the Capitol, having to help out, provide analysis and testimony. Same thing in 2013. Another push to really fundamentally change the system, didn't go anywhere. 2014, another push to fundamentally change the system, didn't go anywhere. 2015, I remember that one distinctly because me and Tom were on the front lines together on that, but that didn't go anywhere. So the reform attempts kept on getting rejected by the legislature overall. So that's a short segment here, but the idea is to understand that from the 90s up until the new story that we're going to get into with these reforms, there were these attempts to change it, but overwhelmingly, whether it was through the voters or through our elected representatives, there was never enough support to fundamentally change the system and do away with the system as we knew it. However, as we move forward in time, there became problems with the no-fault system. I would say that anybody who knows about the system over the last 15 years would say that there are various ways in which the system became inefficient and problematic on certain fronts. Now, I'm not saying that to say that the system was fundamentally flawed. In fact, the whole point of our position on this is that it wasn't fundamentally flawed. It needed to be fixed in certain ways. And so here, I'm going to get into some of these problems. So, if you really want to know the whole story here, you have to also know that while the legislature was not able to change the law, while the voters rejected changes in the law, the Supreme Court became a huge player in what the law really was going forward. And over the last 15 to 18 years, pretty much since about 2000, when there became a majority change in the Supreme Court, that was, many say that the majority of that court was somehow, some way prone to issue decisions that benefited the insurance industry. Maybe they say that they did it for good reason, but if you look at their track record, there were a number of decisions that the court has decided, especially from 2000 to 2012, that were very pro-insurance company friendly. That changed the system. That changed the system in terms of uncertainty about legal standards. It restricted benefits, and it became so that the real way that changes were occurring within no-fault was through the judiciary and not so much through the legislature. So that's a big part of the story. In general, it just made it so it was more litigious and I think just more contentious and overall less efficient. An example of how a decision by the Supreme Court, I say, really fundamentally changed how the system was operating from an efficiency standpoint, was a decision where, and I know there's a lot of text in this slide, but let me try to summarize it for you. The court took up an issue that really sounds technical, but it has a very substantively important aspect to it. And the issue was whether a person who sues an insurance company for a wrongful denial of benefits, whether they'll be limited to recovering benefits that were incurred within 1 year from the day of that lawsuit, or could they go back and claim benefits for for the time that they were dealing with their insurance company, waiting for a response, even if that took them back more than a year. The reason why you had this 1 year issue is because there is in the statute something known as the 1 year back rule. But the courts had previously interpreted that rule to be basically put on pause while the consumer was waiting for a response from the insurance company. And that could be for a couple of years if there are a number of different claims on a catastrophic injury. So what that allowed the person to do is not file the lawsuit while they were waiting for a response. And what happened in the case of DeVillers versus ACIA, the court said we're no longer going to allow them to push the pause button. A year is a year. And so the rule is you file your lawsuit and you're limited to a year. And the reality for claimants was that when they were facing a situation where they had a claim that hadn't been paid and that year was coming around from when they incurred it, which is really when they received the treatment from the doctor, they had no choice then to file a lawsuit. And the dissent in this case said this about the reason why he was dissenting and the impact it was going to have on the system. An insured engaged in the complex day-to-day dealings with an insurer that are common after a serious accident would quite conceivably destroy any semblance of goodwill and cooperation by filing a lawsuit before the insurer has even denied a particular claim. Further, an insurer could simply defend by stating that the plaintiff's claim is premature because the insurer is still investigating the claim, at which point the lawsuit would not only have precipitated antagonism, but would have amounted to a colossal waste of time and resources. And by the way, this is from Justice Michael Kavanaugh, who's a resident of our community. Maybe many of you have met him before, but here he is. He goes on. Insurers, too, are hurt by today's ruling. With the proliferation of litigation that is now bound to occur, insurers will be paying the cost of defending the lawsuits and converting resources that could otherwise go toward investigating claims and communicating with their insurance into payments for billable hours. This will in turn translate into higher premiums, further denigrating the opposite goal of the No-Fault Act.
And I should note that Justice Kavanaugh's daughter is in the front row.
That's right. So what do we have here? This is a chart that summarizes information compiled by the Michigan Supreme Court about the number of trial court filings on no-fault cases. They have a way to code cases in court filings. And when you file a no-fault case, a case to recover no-fault benefits, it's coded a certain way. And so you can get the data about how many of these lawsuits are being filed around the state of Michigan. 2005 is when DeVillers was decided. 2004, 2005, you see there are about 3,000. It goes up to about 600. The next year, 2005, the year DeVillers is decided. And then boom, all the way up to 2017. Within about 10 years, the number of lawsuits on no-fault benefits increases from 3,000 to 9,000, or over 9,000. And guess what? The number of accidents actually went down a little bit. Not too much, but didn't really increase, so it's not the number of accidents that have increased, but yet all these lawsuits. Now, I'll tell you, the 1 year back rule issue I'm telling you about is not the only reason why this has occurred. There are other reasons, I'm going to get into those, but I can tell you as a practitioner, this 1 year back rule really became a problem. And there are so many times our law firm is looking at a situation where we're representing a person and we know that a certain bill isn't paid and there's no other choice but to file a lawsuit. So these are examples of how the system started to have inefficiencies and issues. There's this other issue. As much as it is great to have a standard about what's reasonably necessary for someone's care, recovery, and rehabilitation, there was this other standard about the rate of payment, which said that the insurers had to pay a reasonable charge for medical expenses. Well, that sounds reasonable, right? A reasonable charge sounds reasonable. But here's the issue. It's not defined. Imagine going to the grocery store and the jug of milk was priced, what's reasonable? And everybody's at the checkout line, people would be arguing what the heck the milk cost, right? Nobody would get out the grocery store. And really, that's from my standpoint, and Tom, I think, would agree with me, and anybody who's practicing this area would realize that, or would agree, that this reasonable charge standard created all kinds of unnecessary disputes. It created incentives for insurance companies to argue that the reasonable charge is lower. It created incentives for medical providers to say it should be higher, and everybody had to argue over it. And it wasn't very fun for anybody, but this was the lay of the land, and here's an insurance bulletin from the insurance commissioner, just this last, or 2018, where they're basically reinforcing the idea that insurers should go out there and challenge what's reasonable as a way of keeping down costs, but you can see in the big picture what this is really endorsing is this concept that we're all going to be fighting and fighting over price. And that was a real burden on the system, at least from our point of view. Other examples, independent medical exams. There were no standards really that applied. Insurance companies could notice up people, their claimants to go be assessed by some doctor who may never treat patients with that type of injury, who really doesn't have good qualifications, does a basic exam and then uses that to deny all benefits. There just really were no standards of any significance, and when it comes down to it, that created more fighting too, because people had to go then defend the denial of benefits that came from the independent medical evaluation, and that created more problems as well. Then we have the insurance rate problem. Now this is a graph that's from the Mackinac Center, which is very pro no-fault reform. If you do some research online about where Michigan ranks, it's not necessarily the highest in the country, depending on what stats you're looking at, but it's always up there. And while all this stuff was going on with the Supreme Court changing the law, making it more restrictive in certain ways, these other problems I identified, people's insurance rates were going up, especially in certain areas of the state. In more urban areas, Detroit they always had a problem with rates, but it became worse and worse, and so people started to really cry foul over how much they were paying in insurance. Now, I will tell you, and I want you to watch this video if you don't mind. Hopefully it'll play. Are we in audio? Yeah.
No, you're not.
Oh. Okay. That's good. I'm sorry, I didn't think about that. There's no audio. Are we capable of doing that or no?
Not quickly, no.
Okay. All right. Well, maybe we can do this after the break. But sorry about that. So this video is a guy by the name of Doug Heller, and we're going to talk about him again throughout the course of tonight. And he was an insurance consumer advocate and insurance rate expert, and he has done a bunch of work for various groups that we work with. And when I'm talking about the insurance rate problem, it's clear that people pay too much for insurance, but there's some misconceptions about what that problem is really all about. First of all, those who wanted to do away with the no-fault system typically would frame the insurance rate problem in such a way where they would say no fault is the problem. But there are other issues that played into how much each person paid. And this video was going to show you all the ways in which people pay more for reasons that don't relate to how good of a driver they are, whether they have a certain degree of education, whether they what gender they are, what occupation they have, whether they had a lapse in insurance coverage, their credit scoring. There are all these different ways where Doug would explain to people, and he went about the state doing a number of these presentations where he was able to show there's a lot more to the insurance rate issue than just no-fault insurance coverage. And it's particularly the case about this issue with regard to people who live in urban areas like Detroit and how much more they pay based on these non-driving rating factors. By non-driving, we mean factors that don't relate to how well someone can drive. Am I able to advance here? Well, now, another example of where the insurance rate problem came up in a way that's just different than the issue of we pay more because we have no fault was with respect to this somewhat technical issue, but try to follow me on it because it's pretty significant. The one thing we didn't cover in the first part of the presentation is that while we all, under the original law, had the obligation to buy lifetime coverage, we could choose to pay a bit less on our premiums to have that lifetime no-fault coverage coordinate with whatever medical expense, with whatever health insurance coverage we have. So Some of you may know this, maybe some of you don't. My experience in talking to clients is that they buy the insurance, they don't quite understand how it all works until they're in a crash, and then they have to. But the way it would work is that you would be able to go in and say, I'm insured under a Blue Cross policy. I want to buy coordinated no fault. And you should get some type of reduction for that. Because what's going to happen for your auto insurance company is that they are going to pay only for what Blue Cross doesn't pay. And so you could get a reduction for elevating health insurance to pay primary. And that was a choice. So they say we had to have a choice, but there was this choice to coordinate. And the thing is that the law said that people who selected this choice were supposed to get an appropriate reduction for elevating their health insurance to pay first. And this is a pretty significant liability shift. And these policies, no-fault carriers didn't have to pay for the front lines of medical care for the most part because those were paid by health insurance. And a lot of the post-acute rehab was covered by health insurance, or is covered by health insurance. So when people select this, they should get a reduction that is not insignificant. And in fact, the statute says appropriately reduced premium rates. So our firm, there's actually our father George and our previous partner Tim Donovan, who handled this case called Darmer versus Citizens. And in this case, this issue about whether Mr. Darmer, whether he got an appropriate reduction for his coordinated no-fault policy came up. And it led to depositions being taken of people in the Department of Insurance Financial Services and the Attorney General's office who were connected to auto insurance matters. And these people testified that they had no mechanism in place, no way of making sure insurance companies were actually appropriately reducing coordinated premiums. And that they basically were letting the insurance companies just give whatever reduction they saw fit, and there was no kind of oversight. There was no scrutiny as to what this reduction really was. And this was the case for 30 years. And so when you talk about insurance rates, there is a number of issues that have to be assessed. And then you look at whether the rates are fair for certain people. And then you look at a big issue like this, where possibly for 30 years, nothing was really being done to make sure that people were getting a fair bargain when they bought coordinated no-fault coverage. And I would tell you, about 80% of drivers, it's been estimated, get coordinated coverage because it's cheaper, whether they know it or not. So, Tom is going to tee up this next part. This is what time do we have here?
It's about 7 minutes to 8.
Okay, yeah, I think we can cover this and we'll take the break. Yeah. Okay. So this part is the controversial path to reform. Tom's going to talk about the events that happened over the last couple of years that led up to the moment that allowed these reforms in 2019 to pass. And then we'll take our break and then we'll tell you what these reforms are all about.
So, I think if you're like most people, you probably heard the news that this law was changed this year, and it seemed like just poof, all of a sudden it happened. Came back from Memorial Day weekend, we had a new law. But what in fact actually has been happening is a metastasizing of an idea. An idea that the insurance companies have really been harping on, as Steve mentioned, all the way back to the 1990s, and then kind of went dormant for a while, and then came back to life in Detroit, and was given life by the mayor of Detroit, the current mayor of Detroit, Mike Duggan. And it's those concepts that came back in Detroit about 2-3 years ago that ultimately led to where we find ourselves right now. So let's go back to 2016. Does anybody remember, there was discussion at that time of Mike Duggan wanting to have a type of insurance that he was calling D insurance. D as in Detroit. Well, Mayor Duggan came out around 2015, 2016, and he said, I am going to get auto insurance reform done. I'm going to make it happen, no matter what. And he started by saying, what I want to do right now is I want to completely change the no-fault, the auto law system, but I only want it to apply to people in Detroit. I want to have a system where people can get just a little bit of medical benefits, where they can choose. And the reason I always say choose is because when you're talking about health insurance, how do you really make a choice about how much to cover yourself for if you don't know what's going to happen to you? How's that? I don't understand how that's really a choice. It's a guess. It's a guess. Call it a guess. Can't really call it a choice. I mean, would anybody here go out and buy a $40,000 health insurance policy? Any takers on that? No, of course not. Because you don't know when you're going to get sick. You don't know how sick you're going to get. But Mayor Duggan wanted to apply that concept to auto insurance policies sold in Detroit. And he started back in 2016 with a series of bills that would limit themselves to, it wasn't written as Detroit, but it was written as any city in Michigan with a population exceeding 800,000 people or something. There's only one of them. And Mayor Duggan, who's a very politically savvy mayor, realized that he needed support for this movement because he did have a point, which is that people in the city of Detroit were being charged, and still are being charged, a lot for auto insurance. A lot more than people in Grand Rapids. And you can't lie, those are the numbers. Now query what the fix is, and query why they're being charged that, right? But the end result is the end result. And so he said, I need political relief. And so he then enlisted people like Dan Gilbert, owns Quicken Loans, and apparently half of Detroit. He said, you're going to help me with this, because this is an urban issue. We need to fix this issue, because I want people to come back and repopulate the city, so I have a bigger tax base. I don't want people living in the suburbs, or I don't want people staying away from Detroit because they're afraid of the cost of auto insurance. Well, the de-insurance concept didn't get out of the Michigan legislature. But Mike Duggan was not deterred by that. Matter of fact, he was emboldened by that. He said, fine, I'm going to come back and I'm going to take de-insurance statewide. I'm going to come back to the legislature with a bill that takes this concept of choice and limiting what's in this hand, changing what's in this hand, making these hands kind of all intermingled and confused, and I'm going to I'm going to find some people who will sponsor a bill that will create that concept, not just for Detroit, but for the whole state. And that is what was known as House Bill 5013. And the vote over that bill took place in late 2017. We were there. I don't think the vote was cast till what? Maybe midnight, 11:30 at night. And it came within a few votes of passing. And this is not a Republican versus Democrat issue, as Steve said, or we wouldn't be where we are right now. And back then, Governor Snyder was governor. Republicans controlled the House, Republicans controlled the Senate. So if this was purely a partisan issue, then passing that bill would have been easy. But there was a bipartisan block of legislators who said, no, we're not going to do this. And they said no for different reasons. There were a group of Republicans who, and this isn't necessarily true of all of them, but many of them understood a couple things about this idea. And one of the things that bothered many of these legislators the most was that, you know what, if you take away health care out of the no-fault payment, it's going to go somewhere. And the somewhere it's going to go is to the taxpayer. Because if the auto insurer doesn't pick it up, and the person doesn't have health insurance, then the only place people can go in our society are where? Medicaid and Medicare. And so there were plenty of conservative Republicans who says, I'm not going to give a giveaway to private industry just to shift the burden of health care further back onto the taxpayer. And And then there were people there were legislators from Detroit who said this doesn't give us any real rate relief. And what it does is it treats people in the urban core like second-class citizens. Because it says, if you're not wealthy enough to afford the best auto insurance, then you get lousy auto insurance. But it's good enough for you. And there were people from Detroit who said, that's not fair. You shouldn't be treated that way when it comes to health insurance just because you're poor. And so that bill failed by just a few votes. Never got to the Senate because it failed in the House. In the background, there were plenty of people, including us, who were saying, you know what, we have to fix certain things about this system. Like Steve said, we can't have a system where the price of medical service is that which is reasonable. It's dysfunctional. We have to have a system that has meaningful oversight of the rates that people are being charged. If you're going to buy a coordinated health auto insurance policy that offloads all the risk, or most of the risk, of your health care on a Blue Cross Blue Shield, then you darn sure should get a real reduction in your premiums. We have to do things about the MCCA, this fund that takes care of people who have catastrophic claims, about making them more transparent. Because why? Because they charge everybody. Everybody gets an assessment from the MCCA. We have to deal with this one-year problem. We can't have people filing 15,000 lawsuits a year just because this clock is ticking. We should let the clock go on pause. And so there was a package of bills that was sent to the House, was drafted as a package of bills, and the House Insurance Committee, chaired by then Representative Lana Tice, said, I'm not giving you a hearing. It's not happening. And it didn't happen. So, 2018, 2017, of course 2017 came and went. 2018 is what? An election year where little to nothing gets done, except the election. And we ended up with what? Divided government. Republican House, Republican Senate, a Democrat in the governor's office. And January rolls around. And what do we hear? The first agenda on everyone's list is auto insurance. Not just the Republicans in the House, not just the Republicans in the Senate, but Democrats in both chambers and the governor herself. They all agreed this was going to be issue numero uno. And the governor said in her State of the Union, or State of the State earlier this year, I am eager to engage with any and all people of good faith about ideas and priorities, including your ideas on bringing down car insurance rates. I am committed to the state and to solving problems. Therefore, I will reject anything presented as a quote-unquote solution that doesn't really solve a problem or creates